be agreed to.
Mr Speaker.
Jacinda Ardern.
Thank you, Mr Speaker. It's my pleasure to take a call on this first reading of the Coroners Amendment Bill. I thank the Minister for her summary and explanation of, as to what this bill hopes to achieve. And I'd like to indicate up front that Labor will be supporting this bill. We do think that it makes some sound and necessary changes, as does the Funeral Directors Association, who I noticed very publicly put out their support. Obviously some ties there with the new Chief Executive, obviously keeping a keen eye on what Parliament is doing, but I do understand that they had some input into the review. There are some additional areas, though, Mr Speaker, that we'd like to see at Select Committee, and perhaps if it's within scope, and I'm sure we'll be asking the Minister that question, that we would like to explore, given we have the opportunity to look at the way that coroners are functioning generally. And I want to come to those extra issues at the end of my address. But for now, just to give a sense of scale, in 2012 there were 3,286 incoming coronial cases. So there is a reasonable number of cases that our coroners are having to deal with on an annual basis. Not all of them will lead to inquiries, but those that do, on average, I think we're looking at something like at least a year on average for most inquiries. They're significant pieces of work, so we want to make sure that when they are undertaken, that there is no duplication, that the expectations for our coroners is very clear, and that we make the most of the advice that they then produce. So let's see how the Coroners Amendment Bill makes sure that it does that. Now, the bill, as the Minister has set out, does a couple of things around the way that coroners make recommendations. It will require a coroner's recommendations or comments to be specific to the case, and the evidence before the coroner to be clear about how the recommendations will reduce the likelihood of further deaths in similar circumstances. Look, making coroners' reports relevant to family members or relevant to organisations that they affect, of course, very important. I'd say that many of the reports or inquiries currently probably already do that, but being very clear about them needing to be focused in that way, of course, is useful. Also, strengthening the requirement for the coroner to consider which individuals or organisations have an interest in the death, and to ensure that those individuals or organisations have the opportunity to give evidence. I think that's particularly important if we are going to ask those organisations to pick up recommendations, and particularly if we, for instance, down the track ask for mandatory responses. Up front, having that natural justice process, allowing those organisations to have input, I think will lead to a greater likelihood that those findings are then likely to be implemented. What I'll be looking for at Select Committee, however, is to ensure that those recommendations don't limit a coroner to make recommendations and findings as a consequence of their review that are relevant from their perspective, but maybe they may consider to be constrained by this Act because of how specific their recommendations need to be. So that's just a general test, I think, that we should perhaps test it at Select Committee. We then come on to a few things around process. The bill sets out it wants to improve the use of practice notes. That suggests that there is some perhaps regional variation in coroners' reports. I'd be interested to see whether any specific issues have raised that concern, but I think it's just simply good practice to have that greater sharing. Also suggesting that there needs to be a clarity of role of pathologists and improving the guidance around the retention of human tissue samples. We've seen examples in the past which have caused considerable distress to family, and having clarity there I think is useful. The bill also sets out to better protect the rights of people whose conduct may be called into question in an inquiry by allowing them to be notified and represented. And again, good natural justice process, and if we are going to do anything around the mandatory mandatory response to coronial inquiries, good process up front, applying those natural justice principles means that will be a fairer process. We then come to duplication of other investigating authorities. In fact, one of the and making sure that that the chief coroner has the ability to ensure that no further investigation is needed if another authority has already investigated the death. I'll be keen at Select Committee to seek some examples of where that duplication has occurred. I would hope that what we're aiming for is that the highest bar is applied. So for instance, if we have two authorities investigating a death, that the one that has the greatest independent mandate, where there might be crossover, is the one that's undertaking that inquiry, just to make sure that we're not losing our oversight by saying simply, well, it's already been undertaken by X inquiry and authority, and therefore the coroner doesn't need to be involved. I think we just need to make sure that we maintain the appropriate standard there. So that's something I'll be interested in asking questions on. Then we come to better defining which case need to be reported to the coroner. There's one section here I'm particularly interested in. The bill removes the requirement for a mandatory inquest into deaths in official custody or care to provide the coroner with more flexibility, particularly when the death is from natural causes and there are no suspicious circumstances. I think we have to be incredibly careful in this area that we make sure that we aren't removing from within the coroner's authority deaths in care which may not be all that meets the eye. Now, it's a question I'll ask at Select Committee, because it may be that this can be dismissed out of hand. But what if, for example, a death in care, a death in corrections, for instance, is classified as being of a natural cause because it's an offender who's had a heart attack, but actually if you look at the circumstances, you find that that offender had been in considerable distress and in confinement for a long period of time, for instance. That could be deemed to be natural causes, but it actually would be something that I imagine that we would have an interest in whether or not that was appropriate. It may be that there's good explanation that that wouldn't, for instance, fall under coverage, but I'd be interested to explore that at Select Committee. It then has a number of clauses that cover off deaths overseas, which I think are useful as well. There are some changes to suicide reporting. The Law Commission has done considerable work in this area. I think this will be a particular area of interest for the Select Committee. We've got to make sure that we're making evidence-based decisions in the way that we are guided in both the recording and reporting of suicide in this country. And there has been conflicting evidence in this area. I think that most of this House would agree that we would want to be guided by the evidence and ensure that we're doing right by the general public when we talk about the very sensitive issue of suicide. But coming though to the issues that aren't included in this bill, which I am disappointed by, Mr. Speaker, there's still the opportunity though. In January of this year, in fact, a study that was funded by the New Zealand Law Foundation was carried out by Otago University and released at the beginning of this year into whether or not we could improve the coronial system. Now, the report interestingly argued that this act was the place that we could make some useful changes. They state it's disappointing that the current government does not wish to adequately consider whether the lack of mandatory follow-up to coronial recommendations limits coroners' ability to put preventive principles into practice. They reviewed coroners' findings and basically suggested that whilst actually roughly 31% of recommendations directed to the organisations they interviewed were taken up, 20% were rejected, but for them it was the fact that there was no mandatory follow-up around those recommendations, no mandatory requirement for response. They also said that, well, actually, to do that, doing some of the changes in this bill first would be a very good thing, and so I applaud the government for doing that. They also said that we need to make access to coronial inquiries easier to find. But ultimately, if we're going to make sure that the coroner's work is put to use, then requiring a mandatory response it seems like an absolute no-brainer. In fact, it was supported by the Chief Coroner, who back in 2012, the Chief Coroner at the time, said he would like to become mandatory for coroners' recommendations to be responded to. Not implemented, but simply responded to. Now, why wouldn't we? I'd really like to hear arguments from any side of the House as to why that's a bad idea. And just to give a quick example, the Rotorua coroner, Dr. Wallace Bain, told the Rotorua Daily Post if his recommendations after a Taupo jet ski accident which resulted in the death of Genevieve Lewis had been followed, teenager Bishop Thompson, who died after a jet ski accident, would be alive today. Now, surely making use of all of that work, that time, up to a year per inquiry, all of that funding, I think it's something like 16 million goes into our coroners, then surely we would want to make use of that. Thank you, Mr. Speaker.